I'm Timothy Mutai, representing Topaz Law Firm. Timothy Mutai, and I shall begin my clarification. Your Honor, the case in front of us is one of a somber nature, not only because of the plaintiff's injury, but also because of a misconceived idea of justice, an idea that brings my client, the Academic Excellence University, to this court today, not knowing if she will be found liable and bound to pay for injuries which she did not contribute to. The burden of proof laid upon the plaintiff to prove that my client was negligent involves a threefold test for negligence, whereby one, she must prove that the injury was foreseeable, two, my defendant, two, there was sufficient proximity between the student and the university, and thirdly, that it is reasonable and it is fair to hold my client, Academic Excellence University, liable for that injury. And of those, she has only proved sufficient proximity. But as for foreseeability, when the university would have foreseen any injury whatsoever, the confines of the pitch. But when Flora Monesi, in the presence of ball boys, runs outside the pitch and trips herself on a 5-inch hole, there is no way on heaven and in earth. By my client. Therefore, it cannot be fair, it cannot be reasonable to find my client liable and bind them to pay money. Secondly, onto the law on which the foundations of this court are built, the Occupiers Liability Act, Chapter 34, Section 3.1, which states that an occupier of premises owes the common duty of care in as much as he is free to extend, to exclude, to restrict, and modify this common duty by agreement or otherwise. Your Honor, the waiver that sits on your desk was that agreement, and it excluded, restricted, and modified that common duty of care that my client owed to Flora Monesi. Her agreement is there, acceptance, symbolized by the bold signature imprinted on that piece of paper. The great, late, and most honorable Lord Denning stated that nothing will suffice short of an agreement to waive any claim for negligence. The plaintiff must impliedly and expressly agree to waive any claim for injuries suffered due to the reasonable lack of care by the defendant. And yet, if an agreement can do this, what more can it do when all reasonable care was taken by my client? And finally, Section 4, which states that when damage is caused due to the danger of faulty execution of work, maintenance, construction by an independent contractor, the defendant or the occupier of premises, which in this case was Academic Excellence University, will not be treated answerable for this damage as long as he took all reasonable care to ensure that the contractor was competent and that the work was done properly, which we saw from the witness statement of Patrick Macau that this was done. And therefore, the plaintiff then went on to say that there was duress and they did not treat the agreement well. Well, I would consider Flora Monesi very lucky when I refer to the case of Parker versus Southeastern Railway Company, 1877, where Parker goes at this railway station and he buys a ticket, and on the face is written "See back." And he did not take care to look at the conditions, among which it excluded liability of the railway station for any loss above £10. He ended up losing his luggage was £24, and he sued the railway company. It was held that just by the mere fact the seaback was on the front and gave notice to the conditions on the back, whether he read it or not, that these conditions were binding to Parker. How much so for Flora Monesi? Or maybe even in the case of Thompson versus London Metropolitan and London Railway Company, 1930, where Thompson was illiterate and he could not read. He was illiterate and he could not read. And on the face, the words were written, for conditions couldn't see back. He did not take care to read. And even if he did, he was illiterate. But he was still bound by these conditions. He ended up injured. You say unfair Contracts Act, and yet he was injured. This was an injury. But the court held, the beautiful court held, that the railway company was not liable. And therefore, Your Honor, keeping all this in mind, I believe my client, Academic Excellence University, should not and cannot be found liable and bound to pay damages to Ms. Flora Mwenesi, as this would not be fair. This would not be reasonable, and that would not be justice. Not only in the eyes of men both blessed with sight and even the blind,